This is the current federal tax developments for the week of August the 24th, 2026. I'm Ed Zollers coming to you here from Phoenix, Arizona, and we're going to be looking at a few things this week. It's a rather dense week, lots went on. We have 2 tax court appellate decisions. We have 5 sets of proposed regulations or final regulations this week, an updated IRS fact sheet, an enrolled bill awaiting the president's signature, and a major IRS enforcement announcements on conservation easements. So, get ourselves kind of started with what's going on for the week. There are basically this week 10 items that are roughly in the order they were released during the week. We're going to start with 2 pieces of taxpayer friendly relief guidance: the Form 1041A exception to filing and the Malibu Valley land easement case. Then we're going to move to a significant circuit split on equitable tolling in Kyick Holdings. It's a very interesting split. It's a split that the court bases on a recent Supreme Court case. But the interesting part is there was a case a week ago we discussed on this same issue that considered the same Supreme Court case and came to the opposite conclusion. So it's kind of interesting. Now, from then, we're going to cover the regulation, proposed immigration restrictions on refundable credits. We're talking about pension funding regulations, proposed regulations for the Section 250 FDII fix, the updated Section 163J business interest fact sheet, the LaMalfa disaster relief bill, which is waiting president's signature, the IRS's conservation easement enforcement pivot, and we'll close with the new Trump account investment rules. Now, if you only got time for a few of these, probably the big one this week is going to be Kyick Holdings, the conservation easement announcement from the IRS, if you have any clients involved in anything like that, and the business interest 163J fact sheets are probably the most likely to affect client work in the near future. Okay, well, this first item is good news and a relatively quick one. Treasury is proposing to eliminate a filing requirement that never really made sense in the first place. So we're going to kind of cover this as our opener. This is proposed regulation 109082-25. It was proposed on August the 17th, and it's going to deal with filing 1041As for trusts that have only pass-through charitable deductions. We have, again, like we usually have had recently, we have our illustrations here. Again, download the PowerPoint slides. You'll get the copies of these for this picture. But this is kind of just like the streamlined trust reporting, going to be how we're going to do it. And basically, it's trying to get rid of a kind of ridiculous mandate that a 1041A needs to be filed by a trust that, as a charitable contribution, it is solely a contribution that flowed through to it from a pass-through entity. And it's a little ridiculous because of the original point as to why we had the 1041As. So we'll talk about this. Now, Section 6034's predecessor, which is the one that requires this filing, dates to the Revenue Act of 1950. And Congress was worried deductions were claimed for amounts accumulated in trust that might never actually make it to the charity. Remember, we have special rules here when we can claim a deduction for a charity, for a trust. And well, eventually the trust got restricted a bit more. But even for a trust, we can claim a deduction if you make the charitable contribution the year after the year you claim the deduction. And Congress felt they needed some way to track these sorts of things. In the case of an estate, if the assets are permanently set aside for the benefit of a charity, which I will tell you, I believe is very difficult to really do. We did have about 3 cases in a row on the issue, all of which went against the taxpayer. And then, I mean, tongue in cheek, I've said some law firm most likely just hired the IRS, whoever in the IRS was going after these, just hired them away. So now we're back to nobody understands it, and we don't seem to get this question raised again. But Section 6034B1 requires trust claiming a Section 642C deduction to report 6 categories of information on the Form 1041A, including deduction amounts, payouts, and a balance sheet. And statutory exceptions already exist for simple trust and Section 4947A1 charitable trust. Now, failure to file triggers a penalty under 6652C2 Cap A. That is a daily $10 penalty, capped at $5,000 per return if you are 500 days late. So, it runs up a bit, shall we say. And the issue is a trust holding a partnership or S corporation interest must separately account for its share of the entity's charitable contributions under Section 704A2 and 1366A1, and that's where we get this problem. This isn't the case that Congress was looking to deal with, but the way the language is there is just absurdity, right? This is kind of interesting from that standpoint. So, like I said, you got to pick up your share of the income, right, under this issue. And that alone was triggering the requirement to file a 1041A because they claimed a deduction under 642C on Schedule A of, the K1, or Schedule A, that was based on K1 information received from the S corporation or partnership. Now, a lot of comments were received by charity over the years. Noted such trusts are not accumulating any income that may be distributed to charity in the future, since the underlying entity already made the contribution. This is no future contribution issue. And the requirement created what was referred to as an absurd procedural circle, because they're not doing what Congress was worried about. So it burdened trustees who may lack the information to complete the form, because it may be difficult to get the information that technically you should be providing. Now, Revenue Ruling 2004-5 in Section 1.641C, subsection C-1, right, subsection D2II, already recognized that the pass-through entity, not the trust, makes the actual contribution. So why the heck is this 1041 required? Well, it's not anymore. That's going to be our issue, right? Because Treasury agreed with the commenters here, which is what really happened in this case, right? And it relied upon its authority under 6034B and Section 7805A to decide that these trusts do not fall within the purpose of the reporting requirement, essentially in that case. New Section 1.6034.1 subsection B3 says no 1041A is required if the only Section 642 subsection C deductions come through a K1 from a pass-through entity. That would be the proposed addition. Also, it clarifies in Section 1.634-1 subsection A of the proposed regulations that split interest trust under 4947 subsection A2 must file Form 5227, catching regulations up to the 2006 Pension Protection Act. And the cross references are modernized to Section 6104 for disclosure, Section 6652, subsection D for penalties, and Sections 7203, 7206, and 7207 for criminal penalties. Now, practical form is reliance. You can stop filing a 1041A right now, right? That's fine for currently open years and not just prospectively. Basically, take a look at your trust client list and check for anybody who's filing a 1041A solely because of K1 contributions. Basically, you can pull that out in the future. If, the note to the file is very simple. Under the proposed regs, if there is no, contributions that come from other sources, a 1041A is not required if the K1s are the only reason to do it. Now, I know that people love to do same as last year. So if somebody has a K1 that's been doing charitable contributions every year on the trust, we may have people continue to try to do 1041As. Basically, they're not required. Now, technically, it's proposed regulation, so if the IRS decides to withdraw it, this would change. But since we could actually rely on it now, that's generally not done unless the IRS is pretty darn sure they're going to adopt the reg. So, yeah, we have it going forward. And we would have it until such time as they withdrew it or they issued final regs that are different. Next up is a little more complex territory, a conservation easement valuation case out of the Santa Monica, California mountains. And interesting enough, it's not a Georgia case. The Georgia cases have gone bad, right? Georgia cases tend to be the quarries, and the quarries have been disasters, right? This is a long, very fact-heavy case. It's a really long case to read through, but it's an excellent case on valuation methodology. So we're going to spend some time on it today. Conservation easement valuation disputes come up constantly. So the analytical framework here is worth looking at for this purpose, even if you're never going to see a case of these specific facts. And this is a case of Malibu Valley Land LLC versus Commissioner, Tax Random Decision 2026-868. The opinion was released on August the 17th. Now, we have here a little bit of shift in easement valuation. This is a case where, unlike the Georgia case, right? We've had a ton of the Georgia quarry cases. In this case, the taxpayer really did get a fairly large, not as large as they wanted, but a fairly large charitable contribution. In this case, both the IRS and the taxpayer agreed on the income valuation was the appropriate approach. It had unique facts. There were locked-in development rights, essentially a 1980s protection, a 1980s act locally protected the land from modern, stricter environmental regulations. And those unique development rights were a big play in this value. Okay. Now, the court looked at the sum of the parts, and they actually broke this land into two different pieces, right? Saying that the northern portion was valued based on its different regulatory regime from the norm, and then the southern one was based on the regulations. Now, what that meant was that the northern portion with 22 lots got the vast majority of the deduction. It was $32 million deduction. It's going to get reduced to $21 million in this case, $21,658,000. Because the restricted coastal zone, it was said, nah, that didn't, the old regs don't cover that. We have to use a different thing. It also rejected the IRS's dealer status. IRS tried to argue that this was dealer, but the court ruled that this is an investment from the start. And because the valuation didn't go over 200% of the amount allowed, the claim was not more than 200% of the amount allowed. Claim was $32 million. Allowed was $21,658,000. While it was a substantial valuation problem, it was not a gross valuation misstatement. Remember, 200%, that 40% penalty, because it is 40%, you cannot use reasonable cause. But because they didn't trip the 200, just tripped 150%, they could show reasonable cause, and they're going to get it in this case. So let's go through this timeline. This case has almost 40 years of history, dating from the original 1978 purchase through several rounds of foreclosure litigation and financing. One key issue to take a look at here is Don Hankey's motivation for buying into the LLC. He wanted to ride horses on the land and not develop it. If you take a look at these facts, this fact's important later when the court rejects his numbers as a reliable market comparable. In essence, he's not a reliable source of what it would be. And we're going to have 32 million claims. IRS said 4.65 million was all that they were wanting to allow. And that 40% penalty would have come into play had the IRS won on that. So that's really the big takeaway. There is a huge penalty on the table, right? 40% of, so, take whatever additional tax you'd pay by losing, in this case, over $27 million worth of deduction, and then take that times 40%. We're going to bump it up by 40%. So it's going to be expensive if you lose that point. Okay. Now, the first thing they said is the IRS, as they do in many of these cases, tried to argue they had no donative intent. Court made this very clean and quick on that issue, right? The test is whether the donation was contingent on getting something back, not whether the taxpayer merely hoped for a side benefit. In this particular case, they were asking for essentially in this case, a coastal land, there's a special development rule in this case. The county's response about that availability of this special treatment came after the easement was already recorded and did not guarantee that the taxpayer would receive any benefits. So while they're interested in that, they didn't hold off on the contribution, make it contingent upon receiving that benefit. Since the donee had no basically role in awarding those benefits, the court found the possibility of those benefits was merely an incidental consequence, not a bargain for exchange. Again, key difference. If they had waited, and said, well, we're not going to do this unless you will give us these benefits. And if, let's say the county had said, okay, you make the donation, we'll give you these benefits, then it would be quid pro quo, and then we could have a problem here, but that's not what happened. So in that case, MVL, the taxpayer, possessed the required donative intent, and we have no problem here in that realm. Now, the court did force a single valuation method onto a property that's actually governed by two different regulatory regimes, and that's key, right? The taxpayer had kind of valued the acres as one tract and indicated because there are significant different regulatory regimes govern different portions, the most reliable value method is to value it as the sum of its parts. We'll take a look at the valuation of the northern section and the southern section. Now, the southern section, the coastal section, faced far more restrictions on what they could do. And that ended up with a far less, value assigned to a conservation easement. Because even without it granted, there were several heavy restrictions. But those heavy restrictions didn't apply to the other portion of it, right? And, it also rejected both proposed proxy sales, the 2013 Levin transfer and the 2014 Hankey investment as unreliable, since both were driven by personal circumstances rather than arm's length. Remember, the one guy just wanted to make sure he could ride his horses. So that's not your standard buyer seller. Their motivations there would not be the motivations of a just standard buyer in the market. So there was a separate valuation of the northern and southern portions under California land use law. So what were those two valuations? We look at the northern and southern. For the northern portion, the vested tentative tract map locked in the 1988 development standards. That's a key legal point because it insulated that property from later, much stricter zoning plan. For the southern portion, state coastal law couldn't be preempted by the vesting map. So the theoretical 34 lots were legally absolutely unreachable. You couldn't get there. And the court fell back to a straightforward per acre market approach. Combined, the before value was land was around 21.7 million. And that's worth noting that's far below both the taxpayer's 32 million, right? How far it is from both the taxpayer 32 million, it's below that level, but it's above the IRS's 4.65 million. Right? That gets it there. Now, two separate holdings here to look at in this case. First, the interest deductibility. That's a good illustration of the TEFRA partnership item versus partnership level distinction. The character of the interest is decided at the partnership level, but whether the investment interest deduction limitation actually bites a partner is a decision at the partner level, not the partnership here. Again, a TEFRA one. And secondly, as I pointed out, they got away with no penalties at all because the court did not come back with a value that was less than half of the claimed value. And because of that, even though the appraisal was ultimately wrong, they had a good faith reliance on that appraisal, right? Disagreement doesn't equal bad faith is essentially one of the key things here. They said, disagreement with an appraisal does not establish a lack of good faith. Evaluation later rejected by the court does not by itself establish lack of reasonable cause. So in the IRS, you can't just simply say, well, you rejected it, so obviously it's a bad valuation. Nah, they didn't buy that. Next up is a case that's going to cloud the waters a bit more about equitable tolling. This is the Kyick Holdings versus Commissioner case. Kyick Holdings LLC transferee versus Commissioner. This is a First Circuit Court of Appeals case number 251429. Now, the interesting part about this case is this case will mention three prior Circuit Court of Appeals cases and differentiate itself from them by saying, yeah, but there's been the Supreme Court hearing the Supreme Court case in the interim. But remember last week we talked about was Manticla case? Interesting name. But that particular case there we have, and our illustration makes this clear, the Eighth Circuit in that case considered this Supreme Court case, but came to a very different conclusion from that of the first. Now, this particular case is going to hold. Remember, our question has been if you have a if you have essentially, a 90-day letter, and for whatever reason you don't file in the tax court within 90 days, can you ask for basically equitable, tolling of the statute and potentially get your day in court? The First Circuit's going to say no for an interesting reason, but the Eighth Circuit considered the same Supreme Court case. Again, the other three circuits didn't because it wasn't out then, and came to the very opposite conclusion of the first. So we've got a little confusion here. But this is a method that you may or may not see another circuit pick up to say, yep, there is no equitable tolling. If you miss the 90-day letters, you're just out of luck. So let's talk about the case. So there are two related LLCs, but the same underlying fraud investigation and the same just under $700,000 deficiency. But only one of them got its notice delivered. Kyick Charters got its notice and filed on time. Kyick's Holdings notice bounced back from the United States Postal Service as unclaimed, and by the time counsel tracked it down for the taxpayer and filed, it was 143 days of original mailing. That essentially 11 days versus 143 days framing is the core of the case. The taxpayer acted fast once it actually knew that it was late filed, but the clock had already run from mailing, not from notice. That's the key. So again, the tax court had dismissed this case. Their position is there is no tolling on the 90-day letter for equitable reasons. And unless you are in a circuit that's ruled, yes, you do have to equitable toll this tax court, they're not going to consider it. And this was an appeal coming up under this issue. Now, the exact facts in this case go on last known address, right? And this is kind of an issue that you're going to have about the last known address defense, right? Even though in this case, under Treasury Reg 301-6212-2A, the taxpayer's last known address is the address on the most recently filed return, unless the IRS received a clear notification of a different one. Now, in this case, the IRS argued that the fraud investigation gave it actual knowledge the address was wrong, and it required reasonable diligence to find the correct one. But the court found that even though the IRS clearly knew from its own fraud investigation that the address might be stale, the court held the IRS had no obligation to hunt down every possible address once it mailed to the address on the most recent return. In this case, Marks versus Commissioner, the IRS has no duty to send duplicate notices to every address of which it has knowledge, is essentially the practical rule here. Yes, they were aware of an address they were using on the investigation for both of the entities, but this entity on its last filed return had used the address the IRS would send the notice to. So the court said, nope, we're not going to say that they failed to send the notice, because that had been an easy fix. If the 90-day letter was actually not valid, then it didn't really matter, right? IRS would have to issue a new notice, assuming the statute hadn't run on it. Now we get back to this jurisdictional analysis, right? The First Circuit had to overrule its own 1983 precedent here in order for there to be equitable tolling, because that's a pretty big hurdle usually to overcome, right? Now, but what they can do here is, the Supreme Court's modern clear statement cases can override, in essence, if there's been intervening Supreme Court cases since the time that the original case, what the precedent in the circuit was decided, then they can override the circuit's precedent. Now, in this case, what we're having here is the textual argument is straightforward, pretty much. The filing deadline sentence doesn't mention jurisdiction, but a separate sentence in the same section does limit the court's power to enjoin collection. The court's holding, as the others had on this part of it, that Congress clearly knew how to write jurisdictional language when it wanted to, and it chose not to. So the First Circuit joined the Second, Third, Sixth, and Eighth Circuits now in holding that the 90-day deadline is non-jurisdictional. But there's a second thing to take a look at here, right? In this case, the non-jurisdictional status does not mean tollable. They're referring to the Enbridge Energy versus Nestle case in the Supreme Court. where a 30-day removal deadline was mandatory and untollable because mandatory phrasing, explicit exceptions, and statutory diligence showed Congress's intent. So even though they made the first holding that it was, the language itself didn't mandate jurisdictional, we then go ahead and we, consider other issues here. So Section 6213A already has 3 built-in exceptions: 150 days overseas extension, exclusion of weekends and holidays, and a 1998 safe harbor reflecting deliberate equitable considerations. And that, numerous other code provisions address timing problems through detailed explicit exceptions rather than open-ended equitable relief. So that said, well, using Enbridge, we're going to come to this conclusion, right? That, hey, you can't get equitable, it's just shut off from you. Now, remind you, the case we talked about last week, which does mention Enbridge Energy, it comes the exact opposite conclusion, saying that case doesn't change anything with regard to the 90-day letter. So, right now, pretty much, to be honest, the Second, Third, Sixth, and Eighth Circuits, you have tolling. The First Circuit, now we have precedent post-Batchelor that you don't have equitable tolling. And pretty much everywhere else, we don't know until somebody takes it up to the Circuit Court of Appeals and gets a ruling. So keep your eye on this. What will be interesting is if any other circuit picks up the first. Now, the first obviously had their opinion probably totally drafted before the eighth came out with theirs last Friday. So they didn't go back and redraft or add any language about, analyzing why they don't agree with the eighth. So we don't know how the eighth and the first would resolve their differences. But they are the first 2 cases to deal with this Enbridge case out of the Supreme Court. Next, we go to proposed regulation 119882-25. This is a politically sensitive topic. Just be aware of that. Treasury is proposing to apply a 1996 welfare reform statute to refundable tax credits for the first time in a formal regulation. Compliance is the issue here, right? As I tell anybody in any course I take, I'm not, our job is not to argue the politics of the case, one way or the other, whichever way you feel. I don't care how you feel. Just, well, actually, I probably don't, but that's a different issue. The problem is here we have a reg, it's proposed, and there's a reasonable chance it's becoming the law of the land, right? Subject to somebody challenging it in court. So we need to be ready with that because we're going to have a self-certification form that will be required. And you're going to sign, the client's going to sign that thing under penalty of perjury. So keep that in mind. We have our eligibility rule here. We're really looking at mainly refundable portions of credits and whether they now are covered by an older law that would limit that for certain aliens could not obtain this. That's kind of our background and where we're going. So let's talk about the statutory backdrop of, the PRWORA is a 1996 law restricting non-qualified aliens from federal public benefits. And until 2018, nobody had even raised the question of whether refundable credits count as a benefit under that law. Now, in 2020, there was an OLC opinion that essentially opened up the question, right? And, this first opinion that the refundable portion of credits like the EITC, Earned Income Tax Credit, the Child Tax Credit, and the American Opportunity Tax Credit may reasonably qualify as such. Now, the 2020 memo didn't go back and there was no action at that time, right? But Executive Order 14218, issued in February 2025, prompted a second OLC request. A November 2025 opinion concluded that the Earned Income Tax Credit, Child Tax Credit, American Opportunity Tax Credit, Premium Tax Credit, and Savers Match were all federal public benefits. So, this reg will incorporate those OLC opinions, Office of Legal Counsel, into the proposed regulations text that would take effect. Okay. Now, the conceptual hinge of this thing is really the distinction between what is a refund and a benefit, right? Refunded portions of these credits are not like an ordinary refund, right? Those merely return the taxpayer's own money. that they had held pending the settlement of this. So, you put, you in essence have $2,000 in there, right? You end up getting that $2,000 refunded because the credit reduced your tax to zero. That $2,000 is not what's covered here. But let's say you had a $5,000 credit and it's a refundable credit. Your tax was $2,000 before it. The $2,000 of that credit, that refund of your own money, is not covered by these regs. However, the other $3,000, if you are one of the aliens covered by this, you're not getting the $3,000 under this regulation, right? Because the refunded portion is giving the taxpayer money the taxpayer did not earn, which is funded by permanent appropriation, right, in Title 31 United States Code, Section 1324. So again, the classification here is the Earned Income Tax Credit, Additional Child Tax Credit, or welfare benefits. The American Opportunity Tax Credit is post-secondary education credit, and the adoption credit is treated as a similar benefit. Remember, the adoption credit now is partially refundable. New regulation sections 1.23, 1.23, I should say, -2, 1.24-3, 1.25 Cap A-7, and 1.32-4 implement these restrictions across the affected credit. A non-qualified alien may still use an affected credit to reduce their tax liability to zero. What you can't do is get a refund. Got to be treated as a non-refundable credit if you are in that category, right? So, now, there are some mechanical rules you're going to need day to day. The status rule is timing rule is kind of subtle. The status is locked in as of when the credit is first claimed for that year. So an amended return can help a taxpayer who becomes qualified later, but can't help one who already claimed it while ineligible. Okay, interesting there. In essence, if you were ineligible when you filed the return, right, and then you become qualified later, then you're fine. But if you file while you're not qualified and then qualify later, it doesn't solve anything. You're going to lose it, right? You claimed a benefit that you weren't eligible for at the time you claimed it, right? So qualified alien status determined as of the date the taxpayer first claimed. So that's basically it. There's a joint return safe harbor that treats the other spouse a qualified alien if one spouse is a citizen, national, or qualified alien, which avoided any prorations. They decided that would be way messy, right? And there will be a new Schedule 3A self-certification, right? So if taxpayers who affected credit produced overpayment must self-certify eligibility under penalty of perjury on new Schedule 3A or the refunded portion is disallowed. And Section 7206 make willfully misstating citizenship a felony subject to up to $100,000 fine and 3 years in jail. And false statements are separately punishable under Title 18 United States Code, Section 1015E and 1001. Okay, now, what's not covered yet? The premium tax credit is carved out because the Affordable Care Act and the One Big Beautiful Bill Act already have their own immigration provisions. The Savers match is coming in a separate future regulation. And more interestingly, there's no reliance provision here, unlike for some of our other topics this week. So you keep filing under current law. Don't get ahead of these rules. They don't apply yet. When they go final, then we need to worry about them. I have a feeling, given the the political background that we're talking about in this area, I would not be surprised to see a challenge mounted to these regulations once they go final. Assuming they go final, don't get surprised. Don't be surprised if we see them challenged in court. So yeah, we may have some back and forth here, but do be aware that that there's a decent chance we're going to see this at least become final regulations, and then there may be back and forth with the courts about whether or not it's valid, invalid, temporarily suspended. You know how that whole mess works, right? We were through it with the BOI, so that just is something to keep track of going forward. Now we have more proposed reg, because Treasury is busy with proposed regs this week. This is proposed reg 107855-25, proposed on August the 20th, and these are new rules for single employer defined benefit pension funding, right? So This is for anyone who works with defined benefit sponsors. It's a catch-up regulation prospect. Treasury's finally updating 2009 era funding regulations to reflect over 15 years of statutory changes, right? So it's not a very dramatic topic of the week. You're supposed to follow that, but it's a meaningful one for retirement plan practitioners. So if you're in there, you might want to read up on this and take a look at it, right? We again have our nice little illustration here involving, some of these changes to expense classifications and target normal costs, as well as provisions affecting timing, elections, and anti-abuse rules. Now, this is basic housekeeping, but it's got some real dollar consequences. The existing regulations predate the WRERA, the Secure Act, and Secure 2.0. There's a gap between what the statutes allow and what the regulations implement. The number one fix here is letting a benefit increasing amendment adopted after year end still count toward that prior year's funding target. And so that affects your deductible contributions. That was added by the law in the interim, but our regs don't really reflect this at all. So we got there, right? So again, these are proposed regulations under section 403 G3, 403 subsection G3B, section 430, that's 430 say G3B, under 430 subsection H3, and a general authority of section 7805A. So these minimum funding rules, sponsors that adopt these benefit increasing amendments after a plan year closes before the deadline face some hurdles in counting these amendments for the preceding year. Under these proposed rules, late adopt amendments can be taken into account in that plan year's actuarial results, increasing the plan sponsor's deductible limit. Other fixes clarify the target, include target normal cost expenses, add rules for retroactivity of adopted plans, and delete obsolete 2008-2009 segment rate references. So cleanup is what this is pretty heavily. Now, this one, when we talk about the plan-related versus investment-related expenses and retroactive election, is relatively technical. If you're not in this deep, just it's there. If you are, you need to get the regs out and start going through it, right? The retroactive elections portion is the more useful part. Secure Act, Secure 2.0 already allow retroactive plan adoption, retroactive benefit increases, and these regs finally coordinate that with the funding calculation. There is a timing trap here. The funding contribution deadline can fall, and this has been a problem with a defined pension plan, I should say, defined benefit normally these days, but if you still got a money purchase or target benefit plan that covers those too. Any plan subject to the minimum funding rule, and let's say that entity is a sole proprietor, the sponsor is a sole proprietorship or a C corp, the minimum funding rule, let's say on a calendar year C corp, calendar year that calendar year individual, calendar year C corp, and a calendar year plan, the minimum funding deadline is essentially going to be on September 15th, while the amendment deadline, which could change your funding, goes till October 15th. That means September 15th is the practical date, right, for all practical purposes. But it is one of those problems, right? We have that particular issue that we get here, right? All of those backgrounds. Okay. Now, anti-abuse modifications, we have that. It's key to a specific disproportionate increase test rather than a blanket rule, so it gives the sponsors more flexibility. If an amendment disproportionately increases cost, if the percentage increase in target normal cost is more than twice the percentage increase in funding target, that's going to see. And there's the effective date. Full application 6 months out, but you can rely on these proposed regulations right now for earlier plan years, which opens up some immediate deduction acceleration options. Again, these are technical, involved. If you have a single employer defined benefit plan and you've been dealing with considering amendments, you probably want to get with your plan consultants and start talking about these rules, but just be aware they're there. Also somewhat technical here is international tax topic. This was meant to close a loophole in the FDII deduction that let companies get an export tax benefit on the sale of a factory or patent, not just on the ongoing sales income. If you don't do international work, yeah, you can skip a lot heavily. but the software copyright distinction is somewhat useful still. This is proposed Reg 117-130-25, issued on August the 20th. We again have our new FDII landscape now, what's excluded from being able to be considered to be property sales income, and the things that remain eligible. That's on our illustration. Again, it's on the slide on the screen if you're watching the video. It's also going to be in the slides if you download them from the current federaltaxdevelopments.com website. That's where you can find them. Okay, so let's take a look at this loophole here. Section 250's FDII deduction was supposed to reward genuine foreign market sales income. But as originally written, it didn't exclude gain from selling off the underlying intangible or depreciable assets themselves. Miss. Yeah, we kind of miss this here. Okay. The One Big Beautiful Bill Act closed that gap by adding a seventh excluded category. Note the carve out for leases and licenses. Those still count toward the DEI base. Only outright sales are excluded under this particular structure. Now, other excluded property, some definitions here. Property that in the seller's hands is subject to depreciation, amortization, or depletion. A sale or distribution follows general tax law principles, but excludes anything characterized as a lease or license. Intangible property excludes a copyright article, so transfers of software copies to customers are generally sales of copyright articles, not intangible property, and remain FDII eligible. So, for example, a domestic corporation transferring software copies in perpetuity to foreign customers makes a sale of copyrighted articles, not excluded property, even if it also uses copies internally. And by contrast, a 2-year right to use the same software is the lease, so there's no sale at all. And the income remains DEI FDII eligible either way. That's kind of the background here. Okay. Now, we're going to reject the remanufacturing exception. It was about taxpayers trying to get creative, and Treasury's trying to shut it down. The remanufacturing exception argument sounds reasonable on its surface, right? Where we said that, that it should allow you to repurpose previously depreciated assets for sale. If you added value through refurbishment, shouldn't some of that gain still qualify? But Treasury read the statute as an all or nothing exclusion. The inventory carve out is the flip side. Ordinary manufacturer's goods retain, sales are protected. Since inventory was never of a character subject to depreciation, even the asset itself clearly could be depreciated in a business. It was used in a business. That's not a problem there with the remanufacturing exception. And we also have the anti-abuse backstop, we should say. Moving depreciable property to related entity before a sale won't convert it back into FDII eligible inventory if avoidance was a primary purpose. Okay, basic thing. If you're moving things around to try to avoid this, then it's not going to work. That's a basic issue. Probably isn't terribly surprising to most of you that that's not going to work. Now, the effective date is retroactive to sales after June 16, 2025, with 2 separate layers of reliance available depending on whether the taxpayer wants to rely on either the earlier notice 2025-78 that the IRS had written about this or the proposed regs. You've got to apply those rules entirely and consistently, whichever set you choose to apply early. If you apply either of them in that case, right? They expect to finalize regulations by January 4th of next year. So basically, by January 4th of 27, next year. Got to remember which year it is, right? Basically the end of the year, because that would be right after New Year's. Exclusions generally apply to dispositions after June 2016, 2025. They have the authority to retroactively do it, but you can rely on either for, up until those regs go final. Let's talk about the business introduction under 163J. The IRS revised their fact sheet. They've issued a brand new fact sheet, fact sheet 2026-14, and at the same time had news release IR 2026-94. Both are released on the 19th of August. Now, this one is worth it because it consolidates a lot of OBBA, One Big Beautiful Bill Act changes to the business interest limitation one place. So this one is a good one if you have any clients dealing with the cap. You might want to bookmark this and hand out the fact sheet to them to explain this, how it works. Right? We have our little illustration here to understand a deduction, the 3-part deduction formula, the small business exception, the indefinite carry forward of of disallowed interest, and then what's different for 25 and 26. Change in ATI calculation, expanded floor plan financing scope, and the elections for accepted trader businesses. Again, they're on our little illustration here. You can, find that in the slides. It's on the screen right now. You want to pause, you can just watch it there, wherever you want to do it. So why the update? Why do we get a new fact sheet here, right? Why do we bother it rather than just patch the old one? The IRS decided that the old one had a lot of obsolete materials in it related to the CARES Act. All the CARES Act FAQs are not relevant anymore, but they were in the last fact sheet we had. All those years are closed. Treasury wants to clearly separate genuine statutory changes from mere clarifications as well, so practitioners don't misread the scope. They're going to tell you that some things in the OBB, on the One Big Beautiful Bill Act, merely clarified the statute. That's not a new provision, right? Don't misread the scope. We're going to have that here shortly, right? So again, IRS pulls out the CARES Act FAQs. Pretty much that's what they do. They add some new material and, and new revenue procedure 2026-17 direct practitioners to updated procedures for withdrawing previously irrevocable accepted trader business. And we have the carry forwards. All those things are dealt with in it. Okay. Now, the basic formula here. Deductible business interest cannot exceed business interest income 30% plus 30% of adjusted taxable income, ATI, and floor plan financing interest, right? Now, the updated small business, gross income receipt threshold is $32 million for 2026, right? That's going to be the key issue that we have added in here. If a client's close to that line, mention the protective election option so you don't have to run a full 3-year averaging test every year just to be safe, right? So you can make that protective elect to be treated as accepted, avoiding those sort of receipts calculations if you're close. Now, there are 3 substantive on Big Beautiful Bill Act changes, and they're all favorable to taxpayers, which we should point out. Depreciation add back to adjusted taxable income is a big one for a tax capital intensive business. That was a big issue there, right? In the Tax Cuts and Jobs Act, that went away. Eventually, not immediately. Now we're putting it back in. That directly increases the interest deduction ceiling for any capital intensive business. The floor plan financing expansions is a specific win if you are an RV or camper dealer, although it's a little complicated. So if you haven't been down the floor plan financing rules under the 163J rules, because you weren't working with any clients who had flooring, except for, let's say, you had RV or camper dealers, then you may want to review that. There's some quirks there. And the controlled foreign corporation exclusion closed out a planning technique that a U.S. shareholder kind of juice its taxable income, pump it up using subpart or F or guilty inclusions. The 2020 proposed regs in that area are now essentially dead letters, useless for post 2025 years. Now, what we can do here in this case, right? We have this final one. Revenue procedure 2026-17. Because the restored depreciation add back makes non-accepted status more attractive for a lot of taxpayers previously elected accepted trader business status to avoid the interest cap, the IRS is letting them undo that election. That's a potential planning opportunity. Go back and review that. We talked about that revenue procedure before. Go back and review that and see maybe if you should be paying attention to it. Ladies and gentlemen, we have a tax law potentially. Don't yet have a president's signature as far as I know. So we're still waiting on that. But we have the LaMalfa Federal Disaster Tax Relief Certainty Act. Yeah, that's not going to be a good acronym. So we're just going to say it's a Federal Disaster Act, shall we say? Because DLFDTRC. Yeah, no. That acronym is not going to go anywhere. They didn't spend time on getting a good acronym for that one. They named it after somebody, so they probably figure you should probably want to use the name. So we're going to revise section 165-63 and add a new section 139 cap in. This is an enrolled bill. It's House Resolution 5366, the LaMalfa Federal Disaster Tax Relief Certainty Act, and passed by Congress. It's enrolled. It's on its way to the president. It is waiting for the president's signature. If he signs it, it becomes law, and it permanently replaces a decade of piecemeal disaster tax extensions with a statutory framework that's somewhat permanent. Okay? And these are the basic rules now that are permanently part there. We have some enhanced disaster casualty loss rules, right? So we're going to be getting a $500, the minimum loss threshold for qualified disasters is increased from $100 to $500. However, victims can now claim disaster loss deductions without needing to itemize on the returns. It is a 63 deduction, so it's below the line. Qualified disaster periods, it applies to major disasters occurring between December 28th of 2019 and January 1st, 2027. And, and it applies, we said, to those disasters. Basically, standard casualty loss is $100, qualified disasters $500. Standard would be only must itemize deductions. This one's for all filers. And standard casualty losses have to receive 10% of AGI. This one is waived for disaster amounts, etc. Again, for the most part, the other disasters we're not getting, unless we have casualty gains. So it's a little different there. We also have some permanent wildlife compensation and exclusions. They will be there. That's the new section added to the code. So, like we said, this legislation has passed both houses, not yet signed by law. Waiting on the president's signature, so until it gets that, it's not the law. Now, this converts a bunch of temporary ad hoc disaster provisions into a permanent framework within 165 and 63 and creates a new exclusion under 139M. So basically, we have something there that, well, like I said, disasters are now ending at the beginning of next year. All Congress has to do when a new disaster occurs is just open it back up again. So we don't have to keep adding new non-statutory. In essence, we don't keep adding statutory law, I should say, what it's going to be law that only exists in the actual bill and doesn't exist in the U.S. code. We're going to get rid of that and actually put this in the IRC. We have that issue. 165HF will bypass the 10% of AGI4 for qualified net disaster losses, while other ones will still keep their floor. And qualified disaster area covers any area with an incident period beginning after December 28th of 2019 and before January 1st, 2027, which is a broad retroactive window. Okay. That's going to be kind of the issue there. Now, $100 does stay the floor for an ordinary casualty loss, but qualified disaster-related loss gets a higher $500 per casualty floor in exchange for losing the 10% haircut. So that's your trade-off. So unless your AGI was, $5,000 or less, in which case then you had no tax, you're better off with a $500 floor and no haircut. Right? We're going to be there in that case. The standard deduction fix, which is the bigger deal for most individual clients, we now get to pick them up as a additional deduction in computing taxable income. So again, probably a schedule. Well, it's an additional standard deduction, so it's weird. It increases standard deduction. So probably go on Schedule 1A. But it's not an above the line deduction. That's kind of one of those things that you're going to. By the way, warning: if you're using any sort of LLM-based artificial intelligence tax service, be careful because those services love to treat as a synonym above the line and get it whether or not you itemize. I continue to find that showing up in multiple places. And it's merely because it thinks it's a synonym. It will actually literally give you a paragraph one I just got that literally said that this, is in Section 63. It reduces taxable income. It's an addition to standard deduction, but it still titled it as a new above the line deduction. It's like, no, that language you get even if you don't itemize is what gets them all confused. So just kind of be aware of that, where it's at. Section 139M is a new provision, right? A full exclusion for wildfire relief payments, covers everything from lost wages to emotional distress compensation, as long as insurance didn't already cover it. Double benefit rules are somewhat important to take a note of, right? no double dipping on deductions for expenses paid with excluded funds, and no basis step up from the excluded amounts either, right? So you get that. So qualified wildlife fire disaster is a federally declared forest or range fire disaster that was declared after December 1st, 2014 and before January 1st, 2027. So same sort of background here. And again, provisions apply to payments received in taxable years beginning after December 31st, 2025. Right? We had other rules before. Now, some practical planning implications for this issue. You might have, and you want to investigate some of these cases. There are subtle cases where there might be some amended returns, right? For 2019 to 2024 disaster losses, if you still have a refund statute available. Standard deduction clients who skip claiming casualty loss because it wouldn't have helped them before should be revisited. And wildlife payments specifically remind everybody that good documentation connected to payments to a qualifying disaster is going to matter an awful lot down the road. So make sure you do that because you might have been, you might be receiving some money in either event. You need to prove it really related to that. Next up, the IRS is announcing a new Office of Conservation Easement Enforcement and shutting down the Uniform Settlement Initiative. So this is IRS announcements, news release IR 2026-95 and 2026-55. The first one was there on August 19th of this year. The earlier one was May 13th and announced the settlement initiative, which is now being unannounced. So it didn't last long. Essentially lasted just over 3 months. Okay. Now, the settlement framework that was launched in May, there were various special rules and restrictions. Now we're going to dump that old program. It's not the only way out. We're going to go to this new Office of Conservation Easement. So what changed? Right? What's going on here? The Office of Conservation Easements is a centralized group coordinating policy enforcement and case resolution across the IRS and Chief Counsel's office. You know, this is a permanent institutional structure which suggests it's going to remain around, as a first priority for years, not just a temporary initiative. That's important to understand, but it's going to step in, take over this thing. The original settlement program seemed like a kind of quick and dirty thing. This one may take longer to go. Now, why'd they scrap the May program after less than 3 months? The problem was that they decided the May program just couldn't be administered. It was impractical to work with. A one-size-fits-all rolling settlement letter with a fixed deadline didn't work well across cases with wildly different partnership structures, insurance arrangements, and procedural postures. Now, this is not to be taken as a signal of the IRS softening its stance about these arrangements, at least per, the IRS CFO, who claims that that's absolutely not what we're doing, right? The IRS CFO, Frank Bisignano, said that Congress created created the conservation easement deduction to encourage general preservation, not to subsidize tax shelters built on inflated valuations. So in essence, this is not saying, hey, we're giving up. They're saying, no, this is meant to be a little different. Now, the withdrawn 90-day terms offered a full disallowance of the deduction. This is what you had agreed to. Another deduction for out-of-pocket costs, a reduced 10% gross valuation misstatement penalty with no required upfront payment if you agreed to it. If you didn't agree within 90 days, then for 45 days, you could agree to a less favorable arrangement. The terms were what happened was the penalty was doubled to 20%, in essence. So what's going to happen is first 90 days, we're going to penalize you for essentially 10% for gross valuation misstatement penalty. If you come in after 90 before 135 days are up, we would then go to a 20% penalty. And if you get beyond that 135-day penalty, then it's going to be, any settlement will be based on hazardous litigation terms. And they remind people that that's about a 5 to 7% allowed deduction plus the full 40% penalty. They're not likely. So the idea is their argument is you're not going to get a better deal unless you win in court if you don't basically use the settlement. That was the idea of the original settlement. Now for TEFRA partnerships, that was 2017 earlier years, adjustments resolve at the partnership level, but collections process at the partner level. For Bipartisan Budget Act partnerships, 2018 years and later, the partnership itself is liable absent a push-out election or 6226 to pass adjustments to partners. And acting Chief Counsel Ken Keyes notes that courts have repeatedly found abusive activity in this area, and he warned of substantial litigation risk for taxpayers who keep contesting these cases. In essence, the IRS wants you to settle, but you're not going to go through an office and kind of recognize these tight deadlines and specific things weren't working as well. So they're going to now open it up a bit more. So it does mean you can negotiate a deal, how well it'll go, and you can just ask for these terms if you want. That apparently is still something you could ask for. I don't know if you'll get it, but you can ask for those terms. So he said it's okay. And now our last topic is fairly detailed, but not one that probably most you have to deal with in detail, but you might want to know about it. These are the investment rules for Trump accounts. That was the new minors IRA style based on IRA accounts created by the One Big Beautiful Bill Act. This is relevant for financial planning adjacent practices. Trustees and advisors will need to build compliance procedures around these rules pretty quickly. Again, this is basically, these are final regulations, or I should say, regulations, RAN 1545 BS14, filed on August the 20th. Okay. And so we have eligible investment checklist, mutual funds and ETF onlys. These are going to deal with the 0.1% annual fee cap and strict prohibition on active management, ESG factors, industry-specific indices, and leverage strategies. It will remind you that there is the $5,000 standard deduction. It'll be adjusted for inflation future years, not deduction, but contribution max. $2,500 could be paid by an employer. Employer programs could fund $2,500 of a contribution. And $1,000 is the pilot program, or as our clients will refer to it, the free money. Right? Keep that in mind. And then there are various trustee and management procedures that are in this guidance. There's default investment mandate, must have a default eligible investments right in this issue. There's a mandatory 12-month monitoring rule in here to make sure investments meet the requirements. There is a 30-day remediation window right here. If there's ineligible assets, must be conferenced in that. And then there's the new contribution limits. So let's talk a little bit about this here. Again, quick framing what the account is. It is an IRA for a minor under age 18. Eligible investments are restricted during the growth period to promote low-cost, non-leverage equity. That's key. No debt, right? Money market funds aren't in here. It's equity exposure, right? Treasury assistance on the actual operational compliance, not just correct paperwork. Some commentators had specifically wanted them to say that that in essence that Treasury wouldn't look at, they don't look at paperwork. They wouldn't look at actual operation. But that they were trying to argue that that should be a contractual issue. That that the parent or the kid, I guess, once they turned 18, could litigate over it. No, Treasury said no. This is like a qualified plan. You're going to have to. It's got to follow proper operations, or it'll be disqualified. Right? A trustee doesn't actually follow the rules, risks blowing up the account's IRA status, and it's taxable. So you don't want a trustee that is not going to be following the rules, because trustee doesn't follow the rules, your account blows up and there's tax falling all over returns really quickly. We don't want this. Plus over contribution rules, all kinds of weird things get in trouble. So let's talk about what were the eligible funds and what is considered replicating a qualified index. This is mostly good news for managers and trustees. Treasury basically went along with industry comments here. Right. An ETF is broadly defined to include a registered domestic corporation operating as an ETF or substantially like one. They explicitly include ETF share classes of mutual fund. A mutual fund is a domestic open-end company registered under the 1940 Act. This is not an ETF. Together, these are investment funds. Yeah, the language of the bill used the investment names more than used the IRC terms. So this is kind of how we get here. The rules remove references to advisor discretion and index tracking, clarifying advisors can make necessary decisions and a fund need not hold every index component. A new provision will permit securities lending since it's consistent with passive index replication. So, or since it, yeah, with that, so long as the fund retains full economic exposure to securities lent. And these clarifications respond directly to fund manager concerns that ordinary administrative and trading discretion would typically disqualify most index funds. Right? So basically, yeah, we're going to be in that category. Now, there are two separate standards we're going to look at next, right? What counts as qualifying index and what counts as privileged leverage? On the index side, all equity, primarily U.S. companies requirement is strict, right? S&P 500 or another broad index, right? It cannot be industry, sector specific, or debt containing classes, right? The 90% safe harbor treats an index as primary U.S. companies. Domestic corporations make up at least 90%. And the Treasury moved the earlier sector specific for basically for ESG funds label, but still excludes any fund tracking an ESG index, one with an environmental, social, or governance focus. Those aren't allowed in these plans. On the leverage side of the equation, the shift to a risk-based whole fund analysis for tax is taxpayer friendly. Routine low-risk borrowing or derivative use for redemptions won't disqualify a fund just because it technically involves leverage. Right? So it's a bit simpler in that regard. Now, the fee cap is key, the 0.1% annual number here, right? Annual fees and expenses are capped at 1/10 of 1% annually. And Treasury made clear that includes transactional charges like loads, not just ongoing management fees. Treasury said, look, if we exempted those, they're going to be charged. Everybody's just going to charge them. Because if they're not limited, we're going to go ahead and do that. So, no, if a load fund can't make it here, right? It's going to be it's going to be a very small load. So we're going to be there, right? So that includes custodial, administrative, and advisory fees, Custodial, administrative, advisory fees are separate trustee fees. They're not subject to the cap. Right? That's there. It's kind of background. The monitoring safe harbor, an annual check is going to be involved. Using funds public perspective is enough, which is a big relief because previously they were talking about a continuous monitoring standard. And if a fund becomes ineligible, trustee must sell and reinvest in 30 days. The clock starts to run at the next periodic review, while a non-compliant trustee's ineligibility date reverts retroactively. We have that in there. There are some error correcting mechanisms in here. A separate mechanism protects accounts from administrative errors, such as trustee oversight that misapplies procedures. The trustee must sell the ineligible asset and reinvest proceeds in 30 calendar days, disclosing the error's duration and amount to the beneficiary. The Treasury is also considering a supplemental rule that would let trustees replace lost earnings, but the account would have had if the property properly invested without treating the replacement as a new contribution. These regs will apply to taxable years beginning on after January 1st, 2026, with the trustee procedures provisions, tongue twister, applying once the final regs have been published. And taxpayers and trustees may rely on proposed regulations for earlier taxable years if they follow them in their entirety and consistently. Again, that's everything for this week. As always, you can contact me, Ed Zollers at currentfultaxdevelopments.com, shown on the slide. And given how much regulatory activity we saw this week, 5 separate proposed or final regulation packages plus a circuit split, expect several of these threads to keep developing, particularly with Section 6213 circuit split, 6213A circuit split on equitable relief. Yeah, we just got a new switch in there. We're going to have, remember, Savers match regulations on the alien group. The Treasury says they're coming. Like always, I am monitoring the Arizona, New Jersey, Idaho, Minnesota, Illinois, and Washington State Society of CPAs Connect group. So if you have questions, you post them there and I see your question, I may answer it. Otherwise, I look forward to seeing you all here next week for more on current federal tax developments.